We're going to begin the course by asking a fundamental question of legal philosophy. What's the nature of law? If you ask a chemistry teacher, what is glycerol, she might tell you that it's a liquid and that it's colorless, odorless, syrupy, and sweet. That's a good preliminary answer, but it's hardly a complete one. Other liquids are also colorless, odorless, syrupy, and sweet. An example of this is dextrose. So the teacher's answer doesn't even distinguish glycerol from everything else in the chemistry lab. She could do better by referencing the chemical formula of glycerol. Nothing but glycerol has this formula, and nothing with a different formula is glycerol. And there's more to know about glycerol than even its chemical formula conveys to you. Why is it a liquid at room temperature? Is it toxic to humans? How does it react with other substances? What are its industrial uses? Now imagine being questioned by a young child who doesn't know what law is, or by a visitor from a strange land that doesn't have a legal system. If the child asks you, what is law? Then you could answer that law is the principles and regulations established in a community by some authority and applicable to its people. That's part of a dictionary definition of the word law. It's an acceptable preliminary answer, but again, it's far from complete. It contains words such as established, community, authority, and applicable. These words must themselves be understood. Glycerol has a unique chemical formula, a set of characteristics possessed by all glycerol and only glycerol. Law, by contrast, has no chemical formula. Nevertheless, could there be a set of characteristics possessed by all law and only law? This week you'll be introduced to a branch of legal philosophy that tries to answer this question and to identify the defining characteristics of law. It's called analytical jurisprudence. There are other ways of phrasing the basic question of analytical jurisprudence, such as what is law and what's the nature of law. It comes down to the same thing. Analogous questions can be asked about other institutions, religion, sports, families, higher education, social etiquette, etc. What are the distinctive features of sports? What makes social etiquette different from other things? These are philosophical questions too. Analytical jurisprudence is difficult, in part because law is not tangible or visible. It's not a physical substance or a self-contained physical object. Even if we succeed in identifying the defining characteristics of law, they'll be less concrete than the chemical formula of glycerol. Perhaps the search for these characteristics is hopeless, but we can't know until we try. The fundamental purpose of analytical jurisprudence is simply to understand what makes law different from everything else, and what all legal systems have in common. You might wonder why anyone should care about these inquiries. Most of us can manage perfectly well in life without asking these questions, much less answering them. Of course, we should all know what the laws of our own legal system require of us, but analytical jurisprudence doesn't tell us about any particular legal system. The answers to questions of analytical jurisprudence may or may not have practical implications. It's worth noting, however, that statements made about the law often presuppose that law has a certain nature. Analytical jurisprudence may bear on the truth of such statements. Consider, for example, a famous statement by Richard Nixon. If the president does it, that means it is not illegal. Whether Nixon's statement is true or false depends on what makes an act illegal, which depends in turn on the nature of law, among other things. One way to study the nature of law is to examine a familiar legal system and try to identify its distinctive features. That's a common way to do analytical jurisprudence. Law is a single concept, but different thinkers have different conceptions of it. Philosophers offer different models or theories of law, each of which identifies different features as the distinctive features of a legal system. One influential theory is the command theory, which defines a legal system in terms of a human lawmaker or sovereign. The command theory is closely associated with a great English legal philosopher, John Austin, although Austin borrowed from a fellow Englishman, Jeremy Bentham, and the theory has earlier roots in Thomas Hobbes, also English. According to the command theory, every legal system has a human sovereign who is himself above the law. Austin defines the sovereign as someone who's usually obeyed by most people, and who doesn't usually obey any other human being. If no one in a society fits that description, then the society has no sovereign and hence no legal system. The sovereign issues commands to his subjects. He orders them to act or to refrain from acting, and he threatens them with sanctions, unpleasant consequences, if they disobey. Laws are simply the sovereign's commands. The command theory dominated legal philosophy in the English-speaking world for many decades. In 1961, the command theory was dealt a devastating blow from which it's never recovered at the hands of H.L.A. Hart of Oxford University, one of the most important legal philosophers of the 20th century. Hart challenges three aspects of the command theory. First, He notes that legal rules often remain in force even after the sovereign dies or resigns, so their validity can't depend on the sovereign's commands. Second, Hart rejects one of Austin's basic assumptions about how laws function. Austin assumes that all laws require subjects to act or to refrain from acting. Many laws are like this, of course. Consider, for example, laws requiring parents to feed their children and laws forbidding rape. But what about other laws, like the estate laws, that specify how I must draft my last will and testament? In many jurisdictions, a will is not legally valid unless signed before 2 adult witnesses. The law doesn't require anyone to draft a will in the first place, but it grants everyone the legal power to do so, and it specifies how you must draft and execute your will to make it legally valid. Similarly, the law of contracts doesn't require anyone to make contracts, but it empowers certain people to enter into contracts. It also specifies the conditions that contracts must satisfy if they are to be enforceable in court. These are examples of laws that enable or confer powers rather than requiring action or inaction. These examples are not mere anomalies. In fact, some of the foundational laws of modern legal systems are also power-conferring. Consider any law that establishes a public office, such as the office of police officer or governor, and specifies who may hold it. Modern legal systems couldn't function without such laws, yet they're not easily characterized as commands. This brings us to the third aspect of the command theory that Hart criticizes. This is the command theory's account of our obligation to obey the law, which I'll discuss more in a subsequent lecture. When Austin claims that you're obligated to obey the law, he simply means that the sovereign threatens to sanction you if you disobey. Hart thinks this account of obligation is incomplete. You can feel obligated to obey the law even if you face no threat of sanctions. This might be because the authorities aren't paying attention, or because the law in question has no sanctions associated with it. Hart takes these feelings of obligation as evidence that you really are obligated, yet this obligation can't be explained in terms of sanctions if no sanctions are threatened. Having identified these flaws in the command theory, Hart proceeds to improve upon it. He rejects the idea that all laws are commands of a sovereign, or of anyone for that matter. In fact, he rejects the basic premise that a legal system must have a sovereign. Some legal systems do, but most modern legal systems don't. In modern legal systems, there is no legally unlimited lawmaker. That was already the case, ironically, in the England of John Austen's lifetime. Even the monarch in the House of Lords must obey the law, so laws can't be the sovereign's commands. If laws are not the sovereign's commands, then what are they? According to Hart, laws are rules of a certain sort. Of course, we can't understand the sovereign's commands as rules. But Hart diverges from Austen by holding that one can be obligated to obey a rule of law without threatened sanctions. According to Hart, rational persons have the ability to see rules as reasons for action, even if no sanction is threatened. To accept a rule as a reason for action is to adopt what Hart calls the internal point of view with respect to that rule. If one adopts the internal point of view with respect to a rule, then one's prepared to justify and criticize human behavior by reference to the rule. This includes one's own behavior, as well as that of others. Despite Hart's criticism of Austen, the two agree on 2 basic theses. The first is the social fact thesis. What constitutes the law in a certain society is ultimately a matter of social facts, facts about the mental states and behavior of certain individuals. Put more simply, the social fact thesis states that the laws of a society exist and have meaning, if and only if human beings create them and give them meaning. The second thesis shared by Hart and Austen is the separability thesis. There's no necessary connection between law and morality. For many years, the social fact and separability theses jointly defined the position known as legal positivism. But in the late 20th century, positivists began to abandon separability, leaving the social fact thesis as their only defining thesis. There's more about Hart's influential version of positivism in the assigned excerpt from his 1961 book, The Concept of Law. In the next lecture, we'll discuss another aspect of law and legal systems, the rule of law, with special attention to the work of Hart's contemporary critic, Lon Fuller.